It is November 2022 in Vancouver. A man named Jake Moffat has just learned that his grandmother died. Tonight, in the middle of his grief, he has to solve a logistics problem, getting across Canada for a funeral he never planned to attend. So he opens Air Canada's website and asks the support chatbot the only question that matters: how do bereavement fares work? The bot answers instantly, confidently, helpfully. Book the full price ticket now, the chatbot tells him, and apply for the bereavement refund within 90 days. It even links to the policy page. There is just one problem. The airline has no such policy. The chatbot made it up. This is the story of how one invented refund policy became the most important AI ruling in the world, and why every disclaimer under every chat window is quietly making the same argument that lost. To understand how a chatbot ends up inventing airline policy, rewind the industry. In the mid-2010s, every large company rushes a support bot onto its website. Then the pandemic guts airline call centers, hold times stretch into hours, and the bots get promoted from gimmick to frontline. By November 2022, when Jake Moffat types his question, the bot is not a toy. It is the airline's first responder. And understand the metric those bots were hired to move. It is called deflection, the percentage of customers who never reach a human. Every deflected conversation is booked as savings. Notice what the metric cannot see, whether the answer was right. A customer who got a wrong answer and went away still counts as a win. So picture the two lines every support dashboard was drawing that year. Deflection, climbing, celebrated in every quarterly review, and accuracy on the hard questions, the refunds, the policies, the exceptions, not falling so much as invisible because nobody had thought to chart it. The bot was graded on how many people it kept away from humans, not on whether it told them the truth. Jake Moffat did exactly what the chatbot told him. He booked the full-price flights that night, flew to the funeral, buried his grandmother, and came home. Then, inside the 90-day window the bot had described, he filed for the bereavement refund, death certificate attached. And the airline said no, because the real policy, the one written by humans and approved by lawyers, says bereavement fares must be requested before you fly, never after. The chatbot's answer and the company's policy sat on the same website, wearing the same logo, contradicting each other. What followed was months of runaround. Moffat sent screenshots of the chatbot conversation, proof of what the airline's own website had promised him. Air Canada acknowledged the bot had used, in its words, misleading words. It offered a voucher. It did not offer the refund. So Jake Moffat did the thing almost nobody does over a few $100s. He filed a claim with British Columbia's Civil Resolution Tribunal, which forced a question no court had squarely answered. When a company's AI makes a promise, who owns it? Air Canada's defense deserves to be read slowly, because a real legal team submitted it to a real tribunal. The chatbot, the airline argued, is a separate legal entity, responsible for its own actions. The bot, on its own website, wearing its own logo, answering as the airline, a separate legal entity. Sit with what that sentence claims. The website speaks for the company, the phone line speaks for the company, the poster in the terminal speaks for the company, but the chatbot, the thing the company built, deployed, and pointed at its customers, was somehow a freelancer. The argument wasn't just bold. It was a confession that nobody had decided who answers for the machine. Look at the stakes on each side of the table. For Moffat, a few $100s and a principal. For Air Canada, the cost of conceding that every word its automation speaks is binding. 15 months after that November night, a tribunal member named Christopher Rivers read both arguments and wrote the paragraph that ended the debate. It should be obvious to Air Canada, he wrote, that it is responsible for all the information on its website. It makes no difference whether the information comes from a static page or a chatbot. 28 words, read them twice, they are the operating law of the agent economy. The tribunal ordered Air Canada to pay roughly $650 in damages. As money, it is nothing. An airline spills more than that in spilled coffee. As precedent, it is everything. The first clear ruling, anywhere, that a company owns what its AI says the moment it says it. Now look at the bottom of every AI chat window you have ever used. AI may make mistakes. Check important info. Read it again, slowly, and you will recognize it. That disclaimer is Air Canada's argument, written politely. Our machine speaks to you. We are not responsible for what it says. A court has already told you what that is worth. Because here is the loop companies actually shipped. The bot speaks with the company's voice. The customer acts on the company's word. The company denies the promise, and the disclaimer is supposed to absorb the difference. Air Canada ran that loop all the way to a courtroom, and the courtroom sent it back. Because the tribunal never ruled on artificial intelligence, it ruled on something much older. Your word is your word, no matter which mouth you give it. The industry spent years calling these systems agents, and the law simply took it at its word. An agent acts on your behalf. That is what the word has always meant. You cannot hire the labor and disown the liability. The moment your bot speaks to a customer, it is not a feature. It is an employee, with your name on its badge. Trace the failure to its layer, and it was never really the model. Air Canada's website held two truths at once. A policy page saying one thing, a bot saying another. Because the bot was never wired to the company's actual source of truth, that is a data layer failure. The machine improvised because nobody gave it the facts. The rebuild is unglamorous, which is why so few companies do it. One source of truth, and the agent answers only from it. Every answer traceable to the page it came from. And a human at the edge, for the moments where money and grief share a sentence. A man booking a flight to his grandmother's funeral should never have been a deflection statistic. And in 2026, Moffat's little tribunal case stopped looking little. A Japanese insurance giant is suing OpenAI over what ChatGPT told a customer's employee. Pennsylvania is suing a chatbot maker for practicing medicine without a license. Legal scholars are calling it a lawsuit onslaught, and every case asks Moffat's question at a bigger scale. And the courts have found their frame. In the character technologies cases, judges rejected the claim that a chatbot is just a service. They are treating the deployed system as a product. Its interface, its defaults, its guardrails, all design choices you are answerable for. The age of the magic black box is ending. The age of product liability has begun. Watch how fast the docket is filling now. March 4th, a Japanese insurance giant files against OpenAI in Illinois. May 1st, Pennsylvania files against Character Technologies. May 22nd, legal scholars publish on the onslaught itself. 3 landmark actions in 90 days. Each one a company or a state, asking Moffat's question with more zeros attached. Now run the trend line forward. In 2022, a chatbot could only say the wrong thing. The agents being deployed right now can do the wrong thing. Book the flight, issue the refund, move the money, sign the workflow. Capability is compounding. The excuses are not. The gap between those two lines is your legal exposure. So, here's the standard the winners are quietly adopting. Treat every sentence your agent can produce as a promise your company can be held to. Because legally, it now is. Some companies treat bot output like marketing copy, reviewed, sourced, bounded. The rest are running Air Canada's defense and hoping nobody files. Remember where this started. A grieving man, at night, asking a website for help. That moment is not rare. It is happening to your company right now. Somewhere, somebody is asking your bot a question that matters to them more than it has ever mattered to your dashboard. And if you are watching this from inside a company, shipping a customer-facing agent this quarter, with the disclaimer doing the legal heavy lifting and the deflection number doing the justifying, understand which side of Moffat versus Air Canada you have chosen. You are not avoiding the airline's mistake, you are rehearsing it. Our answer is the line this channel is built on. Work is for bots, life is for humans. The bot should carry the routine, the gate changes, the baggage rules, the 90%, but accountability is not routine. It is the most human work a company does. Air Canada tried to automate it, and the court handed it back. 3 lessons from the file. 1. The disclaimer is not a defense. A court has already said so. 2. Wire your agent to one source of truth, or it will improvise one. 3. Keep a human at the edge wherever money and fear share a sentence. That edge is where your brand lives. This was Case File 2. $650 that rewrote the rules for every agent on Earth. Next in the series, a company that fired 700 people, bragged about it to the entire world, and then quietly called them back.